Hello and welcome to yet another episode of Hitbullseye, in another episode of Law Scope. In today's video, we shall be discussing a very recent judgment of Anup Barinwal versus the Union of India. In this particular judgment, basically the Supreme Court has laid down certain guidelines and it has stated that it shall be mandatory for the Election Commission to be now appointed by a committee of 3 people. And now the committee of 3 people is going to comprise of the CJI, that is the Chief Justice of India, the Prime Minister, and the opposition leader, basically the leader of the opposite party. I am Sana, I am the legal expert for Hitbullseye, and let us get into the video and let us try to understand what the judgment is about. So, the Supreme Court in this particular case stated that democracy is inexplicably intertwined with the power to the people. So basically, let us see the quote. Democracy facilitates the peaceful revolution in the hands of a common man if held in a free and fair manner. Democracy can also succeed only insofar as the stakeholders uncompromisingly work at it. So there's a lot of work that goes into working for making a democracy a success. The essential hallmark of a genuine democracy is the transformation of the ruled in a citizenry clothed with the rights, in which case of the Indian Constitution also constitutes as fundamental rights, which are also being freely exercised by the people. So, if we talk about the importance of democracy, the importance of election commission cannot be ignored. So, election commission is basically a commission that is a permanent commission that is constituted or established under Article 324 of the Constitution. Here, the article basically lays down certain powers and guidelines as to how the election commission is to be formed, what are the powers of the election commission, how the election commission is going to work, etc. It is pertinent to note that election commission, at the time of appointment of the election commission, the rule that is applicable or the rule that is relevant is Article 324 clause 2 of the Constitution. So here let us look at what the section categorically states. It states that the election commission shall consist of, first of all, the chief election commissioner. So the chief election commissioner and such members of the election commissioner, if any, as the president may from time to time fix, and the appointment of the chief election commissioner and the other election commissioner shall be subject to the provisions of any law made on that behalf by the parliament, be made by the president. So here what is to be noted is that firstly, when we were talking about who is to appoint the election commissioners, the answer that is given in the Constitution is that the president is going to appoint the election commissioner, and also any appointments that are to be done, the parliament in respect to that can make a suitable law in this regard. So we shall come to this article again in a while. First, let us try to understand what are the job, what are the principles, what are the workings of an election commission. So, as we have already understood, the election commission is comprises of one person who is considered to be the chief election commissioner. The chief election commissioner has the most important place, and after that there can be any number of election commissioner. They are not the chief election commissioners, but they are still election commissioners, and their number may vary from time to time, from as and when required, as and when the situation demands. So right now there is one chief election commissioner and there are 2 election commissioners, so it's a body of 3 persons. So appointment, here it is written that it shall be done by the president till the time the parliament does not make a relevant and a more suitable law. Third thing that is to be considered in this is conditions of service and tenure of the office, and that also is required to be decided by the president himself. Here, let us take a look at the powers and the functions of whatever the election commissioner does. Here, firstly, the administrative functions are basically election commission is responsible for holding and conducting various elections. So these are the elections of the parliament, that is the elections of the Lok Sabha, that is its most mammoth job, and then the elections of the Rajya Sabha, then the elections of the president, then the elections of the vice president. These are all the elections at the center. Then certain elections at the state, that is the election of the basically the state assemblies and the legislative councils. So all these elections are taken care of by the Election Commission of India, and if there are certain other elections that are happening at the district level or at the local municipality level, etc., in a state, then the Election Commission of the state is responsible for conducting all those elections. So here we can see that the highmost, like the upmost level of elections of the state as well as the highest level of elections, that is the elections in the parliament, are conducted by the Election Commission of India. And at the time of conducting these elections, the administrative responsibilities that are bestowed on the Election Commission of India are firstly to determine the territorial areas of electoral constituencies, so that it determine how the constituencies are going to be divided. Then they prepare our electoral rolls of voter based on adult universal adult franchise. Then they notify the dates and they schedule the elections from constituency to constituency properly. Then they grant recognition to the political parties, they grant symbols to the political parties. Then they allot election symbols to the parties, determine the code of conduct at the time of conducting of the election. Then this was with respect to the administrative role. With respect to the advisory role, it is the duty of the Election Commission of India only as an advisory role to advise the President of India in case there is any disqualification to be made of a member of the Parliament. Also, if basically the president is of the opinion that the president's rule or the state emergency is going on in any state particularly, and because of this reason elections cannot be held in that particular state. So basically what happens is, if there is a president's rule in a certain state or there is a state emergency, then elections can be postponed and the term of the previous government can be extended for up to 1 year at a time. So here, while taking such a decision, the president shall seek the advice of the election commission as to what the conditions in the state are and whether the conditions are favorable and desirable of conducting that elections or not. Secondly, third advisory function is that the High Court and the Supreme Court, if they are entertaining any post-election conflict and they are trying to decide whether whether an election was rightly held, whether a person was rightly elected, etc. So here the role of Election Commission of India would be that of an advisory party to be able to tell the High Courts or the Supreme Court what were the circumstances under which a person behaved or conducted himself in an election, or even a political party conducted itself in an election. The last is a quasi-judicial role, that is something that is resembling a judicial role, that is granting of recognition to political parties and solving the disputes relating to symbols. So as you might have heard that there was a very recent conflict between the Shiv Sena, two factions of Shiv Sena. So there were one person Eknath Shinde and another person Uddhav Thackeray were both claiming to be the factions of the both parties were claiming to be the real Shiv Sena and fighting for over the bow and arrow symbol of Shiv Sena. Here the Election Commission came in. It tested. Basically, it gave out 3 tests. One was a majority test, one was then the constitutional test, one was basically based on all these other tests, the organization wing test, the legislative wing test, and all that. The Election Commission of India came to a certain opinion that the symbol has to be given to the Eknath Shinde factions, because that constitutes at the real Shiv Sena. So this is the kind of dispute that the election commission is bestowed with the responsibility of solving. However, we also have to be mindful of the fact that while this very controversy was being answered, the Election Commission of India attracted a lot of criticism, and the reason as to why this criticism was attracted was that at the time there was a vacancy in the election, basically the election commission. So there were two people who were already appointed, but there was not a third person who was appointed. Here a person named Mr. Arun Goyal, basically he was a very high ranking civil servant. He took a voluntary resignation from his place. He took a voluntary retirement, and within a matter of 2 days his motion for becoming an election commissioner was passed, and the moment he became an election commissioner, within a very short period the decision of the Shiv Sena government was given. So it is, as we know, that it is essential in law that justice must not be only done, but it should also be seen to be done. It is very important that the faith of judiciary and the faith of the even the quasi-judicial body is restored. It stays with the public, and justice is seen to be done. Here it was a very, so to say, it was seen to be a very arbitrary act, that one person is appointed and within 18 hours he gives out a decision. The whole process of basically appointment is completed within 18 hours, and he is also giving a decision like that. And therefore the Supreme Court decided that basically it had a writ pending in front of the Supreme Court. The writ was in form of mandamus under Article 32 of the Constitution, and the writ was stating that the manner of election and the manner of appointment of the election commissioners, including the Chief Election Commissioner, is very arbitrary. Now, basically we have already seen that how is it appointed, and we shall highlight what the issue was. How a person is appointed, we have already seen under Article 324 Clause 2, the President is required to appoint the election commissioners. However, it is to be noted that the election commissioners are always appointed by the President at the prerogative of the Council of Ministers. This is because of the fact that in our country, President is merely a nominal head of the state. President is mostly like a rubber stamp, and he does not really exercise his duties. He has to exercise his duties in consultation with the Council of Ministers, which is headed by the Prime Minister. So when we say that the Prime Minister and basically the Council of Ministers is electing the Election Commission of India, then we are stating that there are members, they are eventually the members of the ruling party, and we can basically say that the people from the ruling party are electing the Chief Election Commissioner and the other election commissioners. So here the process becomes a little arbitrary. The process is can be said to be abuse of law. So here a bench of 5 judges sat down to discuss this case. The case is Anup Baranwal versus Union of India, and the bench was led by Justice K.M. Joseph. It was also constituted by Justice Rishikesh Roy, Justice Ajay Rastogi, Justice Anirudh Bose, and Justice C.T. Ravi Kumar. The bench, let us discuss what is the verdict, the final verdict that the bench has given, and let us then discuss the observations that were also given by the same bench. Now, the landmark decision that the bench has given is that from now onwards, the Election Commission of India, the election commissioners, including the Chief Election Commissioner, shall be appointed by a committee which shall comprise of 3 persons. The first person is going to be the Prime Minister. The second person is going to be the leader of the opposition party, and if there is no clear opposition party, then the leader of the largest numerical majority in the house of the Lok Sabha. Second, the basically the third thing is the third party is going to be the CJI, that is the Chief Justice of India. So PM, the opposition leader and the CJI are going to elect the commissioners so that it is a more fair procedure of election. Here, now if we go back into the history a little bit and try to trace how the appointments came into being, at the time when we were discussing the draft constitution, when our the founders of the constitution basically were discussing how the election commission is going to work, Dr. B.R. Ambedkar had stated that specifically he had opined that in order that elections may be free in real sense of the word, they shall be taken out of the hands of the government of the day. Government of the day is basically the ruling party, and be conducted by independent body called the election commission. So the very motive, the very reason of constituting a body called election commission was so that it does not work on the whims and fancies of the ruling party. However, the constitution had also laid down the fundamental problem that it is going to be elected in the manner as provided by the parliament, but till the time it is not done, till that time basically the president can appoint. So basically what we can see is it is a very ad hoc provision, and the forefathers or the founders of the constitution were of the opinion that we in the future, when we are more equipped, when we have the resources, we are going to we or the or our parliament is going to formulate a proper law with respect to the same. However, it has to be seen that it has been more than 75 years of independence and no such law has been formulated. And one of the reasons of no such law being formulated is the fact that any ruling party is basically making the president appoint the election commission, and any ruling party is not in the favor of any law coming in force with respect to this. And the reason as to why this is there is because no party would want to give away its power, to dilute its power to other people. So that is something that we have been following for more than 75 years, but it is not the correct practice in the eyes of the Supreme Court. So here let us take a look at what were the opinions of the Supreme Court. Firstly, it stated that there is no law regulating the appointment of the election commission. Yes, there is a clause that is given under Article 324 clause 2, but here the parliament was required to make a law in this regard, and the parliament has failed to do it. The current system of appointment is in violation of 324 clause 2. The current system was again required to be made by the parliament, and it is not supposed to be a purely executive decision of appointments. Thirdly, the Supreme Court stated that it is bereft of any transparency, objectivity and neutrality. So basically it is a decision that is communicated by the Council of Ministers headed by the Prime Minister to the President, and the President, without any transparency, with absolute opaqueness, appoints the election commission. Usually, and the election commission are the election commissioners are always the people who are favorable to the ruling party. Then the Supreme Court also pointed out that there is ad hocism flowing from the legislative vacuum. So if we see at the time when the draft commission, basically draft constitution was made, and it was being discussed as to how the appointments are to be done, then there were two views and two opinions that were regarded in this case. One, election commission can be a very ad hoc body, and two, election commission should be a permanent body. So firstly, ad hoc body, why? because it was discussed in the parliament that election commission, the main job of the election commission, where it is the most busy or the most mammoth task that is given to the election commission, is basically conducting the Lok Sabha elections, and that is where the most amount of manpower is required. But once these elections are done, then it does not require a lot of manpower. So what is if they are appointing an election commission and a lot of staff to conduct the elections? What are they required to do? This cannot be because of the fact that elections are coming only once in 5 years. This cannot be that election commission is appointed, everybody is appointed and they work for only once in 5 years and they're sitting idle for the next 4 years. This cannot, we cannot basically have that. Therefore, there was another view that it can be a permanent state or permanent body. Here, our forefathers or the founders of the constitution took a mixed view and stated that the chief election commissioner should be a person who shall have a permanent color to his office, and the other people who are the other staffs and the other commissioner can be on an ad hoc or need basis. So here, what the ad hocism or the appointment by the president, they say, is flowing from the vacuum, and the vacuum, why? Because there is no law made by the parliament per se. Here, the Supreme Court further pointed out that there is a requirement for financial independence, and the salaries of the persons, the salaries of the election commissioner should be charged from the Consolidated Fund of India. Here, basically at present, the salaries of the election commissioner of India are equivalent of the Supreme Court judges, but they are not charged from the Consolidated Fund of India. In the Goswami committee, which was formulated to recommend the reforms in the election commission, they had already recommended that the salaries should be charged from the Consolidated Fund of India. But it has been seen that always the parties, the ruling parties or the parliament wants to keep the election commission on a very tight leash, and that is why the salaries are not independent, and that is why the election commission is not able to work with as much independence as is desired or required. So, in return, the counter arguments that were advanced by the Attorney General R. Venkatramani was that he stated that under T.N. Sheshan, Chief Election Commissioner of India versus the Union of India, in this particular case, it has already been stated that the manner of appointment of the election commissioner is correct, and there is no lacuna, there is no there is no nothing that's lacking in this regard. He also pointed out that we work on the basis of Montesquieu's principle of separation of power, meaning to say that the legislature makes the law, the executive executes the law, and the only power that is given to the judiciary is to interpret the law. So here the Supreme Court cannot basically, with respect to Venkatramani's arguments, the Supreme Court cannot, it can surely expand the provisions of the constitution and it can enhance it to read it in a better way, but it cannot strike down the provisions of the constitution. It cannot make its own law stating that so and so and so is going to form a committee, and that committee is essentially going to elect or appoint the people. So it is essentially the color of creating a new law. So it is not maybe judicial activism, but it might be judicial overreach as well. So this was his argument. However, the Supreme Court in its in the answering to this stated that first of all, the legislature was given ample amount of time. It was given more than 75 years to come up with something that the constitution itself has required the parliament to do, and it has failed to make a law, and it has very consciously failed to make that law. And that is why when the legislature fails, it is the duty of the Supreme Court to set the things right, and that is why the Supreme Court will not be falling short of its duties while making such a law of appointment of a committee who is going to appoint the election commission. Furthering this logic and this rationale, the Supreme Court stated that the ground of removal under section 6 of the Chief Election Commissioner and Other Election Commissioners Conditions of Service Act of 1991, it stated that section 6 of these conditions was basically stating that a person who either serves a tenure of 6 years, or a person who reaches 65 years, whichever is earlier, is going to retire or going to be removed from the election commissioner. However, till this point of time, it has not happened even once that a person might have served his full 6 years, and that is why it was noticed that the people, first of all, the election commissioners are not given proper salary, and the salary is not charged from the Consolidated Fund of India. Secondly, they are being working at the pleasure of the president. They are being appointed itself by the Council of Ministers, and they will be removed. They are removed before the 6-year term. So it was also one of the conditions under section 6 that it has to at the time of appointment, the central government or the Council of Ministers has to make sure that they are appointing a certain civil servant, because usually it is a tradition that mostly high ranking bureaucrats are only appointed as election commissioners. So when you are appointing, it is the duty of the president, and when I say president, it's the duty of the Council of Ministers to have checked whether this person has 6 years in his kitty left to serve or not. And till so far, no person has been appointed who has 6 years or more left to retirement, and all of them have retired before the term. And so, therefore, stating all these reasons, the Supreme Court stated that it would be well within its provisions, and it would be well within its rights and duties to lay down a new procedure of appointment only till the time the Parliament does not make a new law in this regard. So this collegium system, the collegium that comprises of the CJI, the leader of the opposition party, and the PM, who is going to elect the election commission, this is only going to work till the time the Parliament does not by law introduce any other law in this regard. So this is all from our end. Thank you and have a good day. If you have any doubts with respect to the judgment or any other doubts, you can always comment in the comment box below. And please do like, share, subscribe the video. Thank you so much and have a nice day.